Yes, Ms Clark.
My Lord, my Lady, bearing in mind the heavy judicial steer, I'm going to deal with point 2 first, which is the legal context.
Yes, in the short adjournment we had a very quick discussion. We just wonder whether we've got all the materials necessary to decide the point, because I think the emphasis of the appeal, if I can put it that way, has rather changed since both the grounds of appeal and the skeleton argument. Not inclined to shut Mr. George out on the point. I think it may well be encompassed in the permission to appeal, just about. So that if there are other provisions of FISMA, for instance, that we need, or authorities that we might need that bear on the problem, I don't know that we have them. So I just throw that out for you both to think about, and if there need to
we can certainly consider
if
that.
there need to be supplementary submissions in writing, we can. I hope you can agree a timetable for providing them.
Yes, right. Shall I develop my oral submissions anyway?
Yes, please do.
We can see how we go or where we're left
Yes.
at the end of that. Certainly what I can say is that the only tribunal authority that I'm aware of in which the tribunal drew the analogy with judicial review is Frensham.
Is?
Frensham.
Yes.
Prior to this cost decision to which Frensham was referred.
Yeah.
Or at least referred back to the main judgment in which Frensham was referred, if that helps. So my overarching submission is that the authority are wrong to characterise or attempt to characterise this sort of proceedings, non-disciplinary reference tribunal proceedings, as effectively the same as adversarial civil litigation. I.e., what they seem to be saying is this is exactly the same as if two individuals fall out over a contract and one decides to sue the other in private law, and they turn up to the High Court, one of them issues a claim form, and on it goes. And it's then really a matter for the parties as to how they run their case and the witnesses they choose to call, and then they all take the consequences in the end. That is just...
And you would accept, I think, that that is the position in civil litigation.
Yes, absolutely, because a party in a private law civil matter does not have any duties, overarching duties, in the sense that it is not performing a public function, it's not a public body, it's not a prosecutor, for example, or numerous other examples. The duties they do have, of course, is to comply with the civil procedure rules and requirements such as disclosure obligations and the like. So of course they have those obligations, but they don't have any overarching obligations to act as what has been characterised in a number of other authorities, in particular in the criminal field, of being a Minister of Justice, for example.
No. I mean, you can, if you are being sued in private law proceedings by a public authority, there are circumstances in which you can raise public law points to attack the decision.
You can. But that's because one of the parties is a public authority. And what we are, I submit, really talking about here is the duties on a public authority, such as the FCA, when it is a party to litigation which is not pure private law civil litigation, which this manifestly isn't. And therefore, in summary, the tribunal was not wrong when it characterised this non-disciplinary reference litigation as not being the same as civil litigation, because it's not. And one can argue about whether the analogy that they chose of judicial review proceedings is or isn't the best analogy that it could have chosen. But that doesn't change the overarching point, which is that as a party to this sort of litigation and as a public authority, there are duties on such an authority that are over and above what would be expected of a mere party to civil litigation of the type that I've just described. And the first reason for that is the legal context as imposed by statute. And again, you've already had a 101 on the essentials of that, and I know that you've read section 133 with care, so I'm not proposing to turn this up in detail. But the reality is that it does impose some fairly crucial constraints on what the tribunal can actually do. So, in summary, unless a tribunal believes that a reference has no merit at all and dismisses it completely, the powers that it has are limited to remitting the matter to the authority with a direction to reconsider its decision in accordance with the findings of the tribunal. And this was set out in the case of Karimji and also Financial Solutions Euro, and I don't understand these points to be in dispute, so unless you want me to, I won't turn up the authorities, but the references is paragraph 8 of Financial Solutions Euro, the cost decision, which is in the bundle at authorities 14, where they cite paragraph 21 of the FSE main decision. But I don't think that you need to have the main decision in order to understand this, because paragraph 21 is set out. But basically what it summarises is that unless the authority, the tribunal considers that the authority's decision to prohibit, and this is a prohibition case we shouldn't forget, the case we're dealing with, is one that's reasonably open to the authority, then the correct course is to dismiss the reference. So let's say, for example, there are 10 allegations of lack of integrity. The tribunal doesn't find 5 of them proved, but says we do find the other 5 proved. And that being so, we can't see that it was unreasonable for the FCA to prohibit on the basis of 5 rather than 10. And that's an example of how the tribunal's role is constrained. They're not allowed to say, well, we don't think on the basis of 5 rather than 10 there should be a prohibition order, because that's not their function. Their function is a supervisory, quasi-inquisitorial function to inquire into the decision that's been made and to a limited extent supervise what then happens. But that supervision is particularly constrained. And so that's why the FSE paragraph 21 goes on to say that if the tribunal isn't satisfied in the
So I think if you are referring us to it,
I'm so sorry. Yes. So yes, I think it probably is. It is the authorities bundle, tab 14, page 196.
This is Judge Harrington again.
Yes. Sorry. 6, 14, sorry. 8, 25. Yeah. So this is paragraph 8 is this decision summarising what was said in the FSE reference decision, and then it says at paragraph 21, and what they mean is at paragraph 21 of the FSE's, the tribunal's reference decision in FSE. So I've already dealt with the first 5 lines of that. I was about to go on to the next bit. It also observed it would be entitled to conclude that if the authority's decision was outside of the reasonable range of decisions, if it were to make findings of fact that were clearly at variance with findings made by the authority and which formed the basis of the authority's decision. So it's only in those circumstances that the tribunal is entitled to say, we consider that it would be irrational to make a prohibition order on the basis of the findings we've made. And that's in fact what happened in this case. Yeah. Because the tribunal in effect found lack of competence and not lack of integrity, and said on that basis it would be irrational to prohibit on the basis of lack of integrity.
Paragraph 9 looks quite JR-ish.
Yeah. So at 22, the tribunal observed that the authority fails to take into account a relevant factor and takes into account irrelevant factors, then its decision will be flawed, with the result that the decision will not be within the range of reasonable decisions open to the authority. So this is where my primary submission, which is this is not ordinary civil litigation, however you look at it, is relevant, because as a part of the fact-finding process that the tribunal has to go through, and then the limited jurisdiction that it has at the end of it, one part of that being, is it irrational for the tribunal to have come to the decision that it has? Then it would be relevant for it to consider, well...
Sorry, do you mean if it was if it's irrational for the FCA to come?
So the FCA, sorry, to come to the decision it did, then the tribunal is entitled to say, well, in making the decision that the FCA did, it considered these factors, but it didn't consider these relevant factors that it should have done, or it didn't ask itself the right questions, etc. And that would all form part of its legitimate function in terms of the fact-finding process that it has to go through. But I don't understand the FCA to dispute, as a general matter of principle, any of what's said in paragraphs 8 and 9, summarising 21 and 22 of FSE. But those on its own demonstrates that this is not ordinary civil litigation in the sense articulated.
It can't be completely ordinary civil litigation because the FCA is a regulator.
Exactly.
It's bringing proceedings in respect of a regulated activity.
Exactly.
And those proceedings are subject to oversight by the Upper Tribunal.
Yes.
It's the nature of that oversight, I think, Mr. George this morning was saying the nature of that oversight is treated as if it were normal civil litigation between two ordinary parties in the way you've explained.
Yes, I know. I understand that that's what he's
It's
saying.
really the nature of that oversight, isn't it?
I understand that's what he's saying, but one has to look at the full context, legal context, in which he makes that point.
I'm not saying
to
I agree.
test it.
I'm not saying I necessarily agree with what
No,
he's saying.
and my submission is that if you look at the full legal context and then test what he's saying against that, it's manifestly wrong.
Yes.
Or put it in the alternative, the appellant hasn't demonstrated that the tribunal got it wrong as a matter of law or principle, which is really the test that they have to meet in this appeal. So those are two parts of the relevant background. And that's what led up, I suggest, to the tribunal characterising its powers on a non-disciplinary reference as a supervisory rather than a full jurisdiction.
Is there a difference between different kinds of reference under FSMA that we need to know about?
There are, because a non-disciplinary reference, there are a number of them, but the one that matters for this purposes is that if all you're looking to do is to prohibit somebody, then prohibition falls within the matters that are considered to be a non-disciplinary reference. There are other things that you can do. For example, if you want to define a person, or a company, but let's say a person, for a breach of the authority's principles for business for approved persons, for example, lack of integrity, principle 1, and you want to fine them, then that is a disciplinary reference to which section 133, which you were taken to this morning, I think by Ms. Mayer, 1335, which is at 011 tab 1 of the authorities bundle. Tribunal's powers are rather wider, because under A, they determine the appropriate action for the decision maker, which is the FCA, to take, and then on determining the reference must remit the matter to the decision maker with any such directions as the tribunal considers appropriate for giving effect to its determination.
So if the FCA decides it's going to fine somebody, say £100,000,
Yeah.
goes to the tribunal says, no, it's too much, 50,000 is right, it will do what? It will send the case back to the FCA
it will
with a
say-
direction to fine £50,000.
It will say in the judgment 50,000, not 100, and then it will go back to the FCA with a direction for the FCA to act, as the terminology says in 1335.
As the,
in accordance with
as
the
the
judgment.
tribunal considers appropriate for giving effect to its determination.
Yes, exactly. Yes, that's exactly what would happen. Or alternatively, we don't think it should be a fine at all.
Yeah.
And then that would go back to the FCA for them to act accordingly.
Right. So in a reference in a disciplinary reference, a tribunal is the decision maker,
Yes.
and the FCA gives effect to the decision of the tribunal.
Yes.
In a non-disciplinary reference, the tribunal can make findings of fact, send it back to the FCA, but it's then up to the FCA to decide what to do on the basis of the facts as found by the tribunal.
Yes. So, for example, in this case, where the findings were not lack of integrity, it was lack of competence, it went back to the FCA, and there were a number of matters that at the end of the main judgment, the tribunal said the FCA should take account of these matters when deciding what to do next. And it was perfectly possible for the tribunal, for the FCA, had it been minded to decide to prohibit on the basis of lack of competence. And we could have ended up with another notice, prohibition notice, warning notice, decision notice, back to the tribunal if anyone was so minded. That could have happened. It didn't happen, for good reasons, we would say. And the FCA clearly felt the same, given that they served notices of discontinuance within 9 days. But it could, in theory, have happened. And there is certainly at least one case where I believe it has happened, or at least it has happened on the basis that the tribunal's findings were less than the FCA's, less serious. But the FCA said we're still going to prohibit, and then it ended up back in the tribunal. I believe it was Karimji, but I'll be corrected if I'm wrong.
Yeah.
So that's an example of how the differences work in practice. Now, I'm not saying that even on a disciplinary reference, the FCA's position is purely akin to a party in a private law civil litigation matter, because they are still a public body, they are exercising statutory functions, they do have a quasi-Minister of Justice role. I accept that term is more commonly used in connection with criminal cases, because what they are doing is carrying out functions in the public interest which have extremely punitive consequences. A prohibition order is career-ending.
So is that the same as other disciplinary proceedings against solicitors or doctors?
Yes,
or
it could easily be, yes, depending on what's being sought. But yes, because there is European case law to suggest that disciplinary proceedings are quasi-criminal, because that matters in certain European jurisdictions. It doesn't perhaps matter quite so much here, so maybe not, even less after Brexit. But that's the serious nature of the proceedings that we're talking about. And on a human level, recognising that the Court of Appeal deals in facts and arguments and not emotions, but the reality is a prohibition order is career-ending.
It has a penal element anyway, because it's a summary offence if you practice in breach of the terms of prohibition.
Absolutely. So it carries that risk as well. But there is no more serious punishment or I shouldn't say punishment, sanction, but really that can be imposed on an individual than a full prohibition order without limit of time. You can't even, arguably, you can't even work as a cleaner in an authorised firm. But I don't have to argue the case in terms of whether this being a disciplinary reference, because it isn't. So I'm not going to develop my submissions on that any further, save to say that I don't accept that even there it's pure civil litigation principles. But it definitely isn't when you get to a non-disciplinary reference, where not only are the tribunal's role in the process, in the whole decision-making process, a critical check and balance to the extremely draconian powers of the authority, but also where its powers to effect change to the outcome are circumscribed in the way set out in section 133, 7 and 7a. So that is the context for the description by the tribunal of its powers being supervisory rather than a full jurisdiction. And it is also relevant to consider the context in which that point arose in Frensham. So I'm going to deal with that now. Now, Frensham can be found at tab 18 of the authorities bundle.
18, I thought that was the main judgment in this case.
Oh, sorry, yes, you're quite right. I think then it must be, sorry. There's always one
17.
reference to note down.
It's in 17.
Thank you, 17. Yes, 17. Yes, sorry, 17. Now, I was actually counsel for the authority in the decision in Frensham. Not that that means I'm going to give evidence to the court, but what it does mean is that I do have a pretty full understanding of what happened. And the relevant bits that you've been referred to, and I would suggest are relevant to this issue, are paragraph 75, which you'll find at page 352, through to 87 and then 88 and 89. Now, I'm not going to take you through every word of what's said there, but the position was this. This was a case where the FCA wanted to prohibit somebody on the basis of non-financial crime misconduct, which was grooming somebody that he believed to be a 14-year-old girl. It was in fact a vigilante, but he didn't know that. He served a prison sentence, he came out, he then spent 3 years working back in his old IFA role before he received a letter from the FCA saying, we'd like to prohibit you. And understandably, he was a little aggrieved. The matter came to the tribunal, and one of the key questions for the tribunal is, why has all this taken so long? Because, of course, one of the criteria that the tribunal had to consider was the risk posed by this person to the regulatory system, which, understandably, Mr. Frensham was arguing was non-existent, given that he'd been doing the role for 3 years after he came out of prison and there hadn't been any problems. And most of his customers were pensioners rather than children. And so the two witnesses that were called by the FCA, Miss Cousins and Mr. Blunt, were the two witnesses that are referred to at paragraph 75 through to 87, and you'll have no doubt read what's said about that. Malone and Friends says, well, this clearly explains why the tribunal came to the conclusion that it did, or made the suggestion that there was analogy between these proceedings and judicial review. Because what they were talking about was FCA witnesses talking about FCA matters. Now, I can see why it's initially attractive to him to make that submission, but I don't submit that it's correct. Because although it is the case that they both were FCA witnesses, and it is the case that they were there to talk in part about the FCA's policy decisions in cases of non-financial misconduct, what they were equally there to do was to talk about the factual positions as regards the delay. What had been done, what hadn't been done, why decisions were taken not to do things when perhaps they could have done, what view the authority took of other particular factors that could or couldn't have been relevant to prohibition. These are all factual issues, and these are the issues that the tribunal just as much felt that they were unsighted on as the more policy issues, if I can put it in that way. And then that's what led up to the tribunal's comments at 87, we're now at page 354, be regarded as unsatisfactory. The authority didn't put forward appropriate witnesses, and those witnesses who did attend were not properly prepared. Then at 88, because often focus on this issue is placed on paragraph 89, but I submit 89 has to be read in context with 88, which says, we understand that proceedings in this tribunal are largely based on the adversarial tradition, which is true. It's a tradition where the party calls evidence, submissions are made, there's cross-examination. It's not an inquisitorial system in the sense that it would be understood in civil law jurisdictions, like, for example, Spain or other countries. So that is right. And normally a matter of choice on the part of a party to which witnesses it will choose to call, i.e. yes, in normal adversarial jurisdiction, it would be up to a party, as in the private law civil jurisdiction that we've been talking about. However, regulatory proceedings of this kind do have important differences from the usual adversarial process of civil litigation. Tribunal proceedings are designed to be more informal and flexible than traditional court proceedings. Now that is also true, and the Upper Tribunal rules demonstrate that, because they in effect say, as most tribunals do, no rules of evidence, tribunal can do what it wants in the interests of furthering the overriding objective, etc. So there's much more flexibility. And it says it will sometimes be necessary for the tribunal to perform a more inquisitorial role. That follows from the fact that the tribunal is part of the regulatory process and in many respects stands in the shoes of the authority when considering the subject matter of the references, which feeds back to my point that the authority is not in the same position as a private individual. They are a public body. And that's the same whether it's a disciplinary or a non-disciplinary reference, and that's the point that's made here. And then we go on to section 89, which is the point that my learned friend particularly complains about, that as regards a non-disciplinary reference, the tribunal needs to consider the procedural and other steps taken in connection with the making of the decision. And then it refers to the tribunal proceedings being very similar to judicial review. It refers to a duty of candour on the part of the public authority, and be recognised in such circumstances that a public authority is not engaged in ordinary litigation, but in a common enterprise with the court to fulfil the public interest in upholding the rule of law. That means that the authority should assist the tribunal with full and accurate explanations of all the facts which are relevant to the issues which the tribunal must decide. Now,
sorry to quibble, but I wonder if paragraph 89 is quite accurate. What is said there is in relation to a non-disciplinary reference, the powers of the tribunal are more limited, and as envisaged by section 1336AC, the tribunal needs to consider the procedural and other steps taken in connection with the making of the authority's decision. Now, that seems to be a reference to the decision which gave rise to the reference. But section 1336A is linking with 1336AC links back to 1336B, which is looking to the future decision of the authority once the tribunal has remitted. And that's why 6AC talks about the procedural steps to be taken. So that's looking to the future, isn't it? That's not quite what 89 of Frensham says.
Yes, the decision to be taken in the future in the light of the tribunal.
But is that is that the same as paragraph 89 of Frensham? It doesn't read the same way, not to me at any rate.
Exactly, because one, as you rightly say, is forward thinking, the other one is at the time of the reference, looking backwards. But my submission would be that it's not wrong to say that, because in order to form a view about the procedural or other steps that need to be taken in connection with the making of the decision, it would be relevant for the tribunal, for example, to identify where there have been lacuna in procedural or other steps so far, and to identify that those are matters that need to be addressed, or to invite the FCA to consider addressing them. So I don't submit that it's wrong to say that, but I do understand that they are not necessarily completely aligned.
Does 6A little b deal with what's happened in the past? And 6A little c dealing with procedural or other steps then to be taken?
Yes, I think that's right. Although 6AB will be the matters that the tribunal has found or hasn't found to be that the authority then needs to take into account in making the decision. So, for example, at the end of the main judgment in our case, this case,
there's a whole list of
there's a whole list of things that the tribunal says you, the authority, should take these matters into account when deciding what to do next.
Yes, the decision in 6AB is the decision which the tribunal have directed the authority to make.
Yes, I think that's right. But that, again, would involve examining the matters that it took into account first time round, in order to identify whether those were the correct matters, incorrect, further matters should have been taken into account. Yes. But my point on 89 is that if one was to, let's say, strike through the bits about judicial review, and if you like, strike through the reference to duty of candour insofar as it relates purely to judicial review proceedings, what's left in that paragraph is an accurate statement of a non-disciplinary reference in the tribunal's role. And, moreover, the authority's role. Because the authority, unlike a civil litigant in a private law case, does have a duty to engage in a common enterprise with the tribunal, to ensure that the tribunal is given the evidence, the material, etc., the assistance that it needs in order to make the decisions that it is entitled to make, and then the recommendations insofar as it's entitled to make them.
Yes. I mean, I wonder whether the common enterprise is fulfilling the public interest in upholding the rule of law, rather than the public interest in having persons of competence and integrity licensed to give financial advice, which is slightly different.
Yes, I know that the rule of law is a lot wider than that, but it would still, I submit, be relevant to the rule of law as a whole, because if you have an unstable financial system as a result of a defective enforcement process, at the end of which is the tribunal that is defective because it is not given the assistance it should be given by the authority as a, in effect, Minister of Justice and public authority, then there is a risk to the rule of law, I would submit. But in any event, I don't think I need to go that far. I think that my submission is that it's plainly a risk to the financial regulatory system if the tribunal's function is being undermined by the authority not taking its position as one of sufficient responsibility. And that would be the same, for example, in a criminal case, where it's well recognised that a prosecutor in a criminal case acts as a Minister of Justice and has that duty over and above getting a conviction.
They don't have a duty to get a conviction at all.
They don't, absolutely they don't.
So it's not over and above a duty to get a conviction. And
that's not always that's not always well understood. But the reality is that their duty is to act as a Minister of Justice, ensure the trial is fair, and that the tribunal, of fact, has the material that it needs in order to come to a decision. And then the outcome is obviously not something that a prosecutor should be personally invested in, either on an individual or a collective basis. And to that extent, and I don't go so far as to say that the authority is in the same position as the CPS when it comes to prosecuting a criminal case, but given, as I said before, the draconian effect of the sanctions that it imposes, it is the case that, and given that this is all part of the regulatory process, a key part of which is effective enforcement, then it does have a role over and above just plain civil litigation, as described in here.
And that's not because it's a public authority necessarily, that is because the nature of the issues for the Upper Tribunal are regulatory issues. It's not like HMRC trying to prove MTIC fraud in the tax tribunal, where you might say, well, that is pretty much like civil litigation, even though it's a public authority.
No, because no, that's a different type of process. Because I mean, there are circumstances, of course, when HMRC are acting as a public authority in the public interest, but I'm not sure I'd describe your analogy as one of them.
No.
But in this particular, let's just focus on what happened in this case. Imposing a prohibition order is a crucially important part of the enforcement function in terms of, amongst other things, deterrence to others, sending out a message to the financial market and the public at large, upholding proper regulatory standards, ensuring that the financial services industry is regarded throughout the world as being a place where people can safely and wish to do business. I mean, there are a large number of public interest factors that can be identified, all of which feed into the making of a prohibition order in a case where the authority alleges somebody's acted with a lack of integrity, which is what we were talking about here. I know there's been reference in this hearing to dishonesty. This case was never about dishonesty. It was always about lack of integrity. Dishonesty was never actually alleged and certainly not proved. So, going back to 89, my point is that whether or not you accept that there is or isn't an analogy to be drawn between judicial review and these proceedings doesn't matter, because it misses the point. The point is actually neatly encapsulated here.
Yeah, your point is that you don't need an analogy.
No, no. And in fact, I think I hope I've said that in my skeleton at paragraph 17. If that helps, it's page 47 to 48. And in particular, paragraph C, which is at 48 of the core bundle. Where I make the point that the other thing to be aware of is that Frensham never said these proceedings are the same as a judicial review. The most they said is they were similar in character to a judicial review. Now, I haven't sought to argue in here that there are direct correlations between a judicial review, either in terms of aim, outcome, process, or the like, and these proceedings. And of course I accept that they have different processes. The duty of candour arises because there's no duty of disclosure as such, and all the various points that have been made by the authority. But what I say is that doesn't matter, because the authority's overarching obligations as a regulator in the context of these proceedings inevitably means they're more than just a party to litigation, and they do encompass, therefore, a duty of candour. And a duty of candour can be expressed in a number of different ways. It can arise in the more traditional context of a judicial review, but it can also arise in relation to when the authority, as it did here, bring a case where they say these people lack integrity because they didn't see red flags and they should have done, or their alternative case was reasonable people would have seen red flags and that's enough to make them reckless and lacking in integrity. But then don't seek to call any of the people who also saw red flags and had the same information that these people had and test why didn't they see the red flags.
Sorry, you said people who saw red flags.
Yes, so people who saw the same information that the FCA say amounts to red
objectively
flags.
saw red flags but didn't
Yes.
realise. Okay.
Yes, so the FCA say, for example, Miss Whitestone didn't see a red flag because in relation to Mr. Merenson asking for his contract to say that this payment was an investment capital gain rather than commission. And that was an obvious red flag that she should have seen. The fact is that others, including Carolyn Thompson-Beelman, had the same information, as did the head of legal at BJB. None of them, it seems, raised a red flag. None of them were called. In particular, Carolyn Thompson-Beelman. That's just one example, but there are a number of others. It was a very heavy, fact-specific case. So,
But I'm at the moment, it's probably my fault. I'm not really understanding why it was relevant to call these other people if what you're doing is criticising 3 people in particular for not having seen the red flags.
because, as the tribunal observed, it's relevant when making a decision about whether these people should have seen red flags and acted accordingly, when others had the same information and didn't themselves see the red flags.
But I thought that the tribunal decided this was an objective question, and if it's an objective question, how other people reacted relevant? I mean, they might all be capable of being criticised by reference to the same objective standard.
The tribunal didn't decide that recklessness was purely objective. That was an argument that was had between the parties, and in the end, the tribunal agreed with the subjects that it is a subjective and objective test, as in R&G in the House of Lords.
Right. So the question is, what did you think subjectively?
So did this person, did Mrs. Whitestone appreciate a risk that all was not as it seemed?
Yeah.
And in the circumstances known to her, was it reasonable for her to have taken the risk?
So as regards the second part of the test, my question is, how is the tribunal going to be helped by hearing evidence from other people who did or didn't see red flags in similar circumstances?
Because it's a comparison exercise.
Well, and I think also one of the individuals was her line manager, wasn't it?
One of them was Mr. Campiano, was her line manager.
And so the issue was if he had she been poorly supervised and or was potentially incompetent rather than being reckless.
Exactly. Yeah, so that's one point. Carolyn Thompson-Beelman had a senior role in BJB compliance and had been specifically tasked with overseeing this relationship. She had a lot of the information, not all of it, but a lot of the information that led to what the authority said were red flags. She's a senior person in compliance. If she didn't see the red flag, then plainly that's going to be relevant to an assessment of, firstly, when my client says, I genuinely did not see that this was a red flag, whether that's more or less likely to be true. And secondly, in terms of the objective test, if another reasonable person, such as Carolyn Thompson-Beelman, didn't see a red flag, then that's plainly going to be relevant as to whether it's reasonable for my client not to have seen it.
But the real point in this, Clark, isn't it? The costs decision wasn't predicated on the stark fact that they weren't called.
No.
It was the finding of unreasonableness in respect of the steps taken.
That's right.
Potentially to secure their attendance.
That's exactly right. And in fact, one of my sections of my submission is devoted to explaining why the authority hasn't actually properly characterised what basis the decision was actually taken on. and what it actually said. You're quite right, because the authority seeks to characterise this as we're being criticised for not calling witnesses. It's much more nuanced than that. It's not only were those witnesses not called, but you didn't address your mind to or take any reasonable steps to secure their attendance, and what evidence you have late in the day produced really rather suggests that you didn't actually want them. Now, I don't know if that deals with that to your satisfaction at the moment, because I don't want to get sidetracked from my point two, given that there's a couple more legal points that I just want to make before I leave it. It's right to say that Frensham wasn't the first case where the authority has been criticised for similar failures in not providing the tribunal with important witnesses. The case of Forsyth, which you've got in the bundle at tab 16, was decided prior to Frensham. I believe the position was the decision hadn't been published at the time that Frensham was heard. It was actually published shortly afterwards. But the relevant bits are at pages 252 to 254. And this was a case that Mr. George was in. And we start at 72. The position was that the FCA called, I don't know if they called any witnesses at all, but if they did, they didn't call witnesses of fact. And they tried to prove the case based on the documents. And the tribunal's view of that at page 72 can be seen where it says, well, the problem is the documents don't tell the whole story. And there's the disadvantage of lack of cross-examination of other witnesses who could have given relevant evidence as to these documents and were not before the tribunal. Now, these weren't suggested to be FCA witnesses, these were lay witnesses, pure witnesses of fact. But the tribunal still complains that it wasn't appropriate for the authority to conduct its case on that basis. Now, going over the page, the rest of it proceeds with a bit of an analysis of the case law about what you can make of documentary evidence and the drawing of adverse inferences from the absence of a witness. And it's right to say, and I acknowledge, that there's nothing in there, in that relevant section, or indeed in Forsyth at all, where the tribunal talks about this being akin to judicial review proceedings or a duty of candour. Given the very specific way in which Mr. George today, phrases his submissions, i.e. Frensham was only decided on the basis that it was two FCA witnesses we were talking about. Seems right that I make that acknowledgement. But I say it doesn't make a difference. The criticism was still there. What the tribunal decided to do in that case was to draw inferences and attach more weight to Mr. Forsyth's evidence where there was a lacuna in the evidence. And of course that accords with the case law that entitles a court to do that in appropriate circumstances. And to some extent that's what was done in this case, in our case, in the Laing judgment. But it would be wrong to say, well, because the tribunal didn't call any evidence in your case, and therefore there was nothing to contradict what Mrs. Whitestone, let's say, for example, said, then the tribunal gave you the benefit of the doubt. So you've got your benefit, and that's the end of it. Because that process relates to what goes on within the context of the decision-making on the facts that the tribunal has. It's not the same as then a subsequent finding for the purposes of a cost decision as to whether it was reasonable or unreasonable for the authority to have put the tribunal in that position in the first place. So my submission is that although Frensham doesn't go quite as far, Forsyth doesn't go quite as far as Frensham, it does not mean that the only relevance of failure to produce witnesses is, well, the tribunal can draw appropriate inferences against the parties in the substantive hearing, and that's the end of it. Now, in terms of the FCA's change of position, I do submit, for the reasons that I've set out extensively in my skeleton at paragraphs 47 to 53, that the authority has, or certainly appears to me, to have rather changed its position. There was a limited acceptance of that from Mr. George this morning. 47 to 53 can be found at page 62 of the full bundle. The position is the authority did not, in terms, or indeed I submit otherwise, assert during the course of the costs proceedings that it did not have a duty of candour or a duty over and above a party to civil litigation. Its case was based on, we could have done better, but what we did wasn't unreasonable, in summary. And it is notable that even now, as I've said at paragraph 50 of my skeleton, that the authority's appeal skeleton at its paragraph 13 does accept in terms that the tribunal has a supervisory jurisdiction only. Which does seem to me, in my submission, to undermine the points that Mr. George makes to the contrary. And so if we are in a position, as I submit we were here, in this case, where a public authority on a non-disciplinary reference within the context of the restrictions on its ability to act under section 133 is not provided with material evidence, witnesses, etc., it is going to have an adverse effect on its fact-finding abilities because it just simply won't have relevant evidence. Now, again, it might be said, well, if those witnesses are called, they may not have helped Mrs. Whitestone. The answer to that is we don't know. My own view is, I think, based on the fact the witnesses that were called were very helpful for the large part, I can't speculate. But
well, I mean, there's another answer which I think Mr. George gives, and that is that you could have called them. I don't. If you thought they were going to help your client's case,
I
then
don't
she could
consider
have called them.
I don't consider that that's realistic when you're talking about an individual with limited means and none of the powers that the authority has, and no means of finding out where these people are, no means really of, or certainly no means of compelling them to provide information or evidence. And
well, that goes for both parties, doesn't it? If there's no means of compelling them, then there's no means of compelling them, whoever is trying to do it.
there are, the authority has some means of compulsion, the individual doesn't have any. But also, of course, it is not the same when you have an individual who accepts part of what a witness says, but not the whole of what they say. Whereas the authority is in a slightly different position where it knows that there are relevant witnesses, but then just chooses not to call them at all. So it's not a fair criticism, I submit, and there isn't parity in terms of the parties. So the focus has to be on as well, who's got the burden of proof? It's the authority. Who is it who wants to impose a draconian sanction? It's the authority. Who is it that's an integral part of the financial services enforcement regime? It's the authority. They're the ones with the public duties in this case.
Yeah.
So focusing on the procedural differences between judicial review and these proceedings is interesting, but in the end, I submit, not actually that relevant, because it's a distraction. From the overarching points, which are equally as fatal to the authority's case, that the tribunals was wrong on a point of legal principle. Even if you think the tribunals could have chosen a better analogy, doesn't mean that it was wrong in terms of the overarching factors that I've set out. And as I've made the point at 52 of my skeleton, it shouldn't be controversial that the authority, on a case-by-case basis, needs to assess the witnesses and evidence that it is required to provide in order to enable the tribunal to do its job. And so what this comes back to is a fact-specific analysis. And unless I can assist further on point 2, can I move to my point 1, where I develop that?
Yes.
Thank you. Now, the value judgment that the tribunal made was made in accordance with the factual context within which it was presented. It was plainly a case where the absence of important witnesses was a striking factor. It included a number of witnesses who were plainly key and could have given highly relevant and material evidence. And I have set out in my skeleton, paragraph 29, the specific factual ways in which each of those witnesses were highly relevant. Unless you want me to go through it all and explain to you why that was, then I don't propose to do so in the interest of time.
No, I mean, the only question for us is, was there an error of law?
Exactly. But there's no, my submission is there wasn't, but when you have got to make a value judgment about whether something was reasonable or unreasonable, you take into account all the relevant factors, one of which is the context. It may not be unreasonable to call a witness that has very little to say of any value. It's different when you're talking about witnesses who have a lot to say about very key issues and were extremely well placed.
Well, speaking for myself, I should have thought the trial judge was the best person to judge that.
Quite, and that's my point. Can I make it clear, and I'm sorry to have wasted Miss Rooney's time in researching and preparing her submissions, but my reference in my skeleton to the other witnesses was not intended to suggest that this court should somehow include that as a finding of unreasonableness. And I suspect had I wanted the court to do that, there would have been rather more procedural hoops I would have needed to jump through. I do accept, however, that the way in which I drafted that part of the skeleton clearly could have been better expressed, so I apologise for that. But can I make it clear what my position is? I am not saying that the failure to call those witnesses was part of the tribunal's decision on unreasonableness.
No.
It plainly wasn't. And I'm not inviting you
So you're
to
saying there was a large pool of potential witnesses, and out of that pool, the authority should have called 3.
They should have called
Or at least made attempts to.
At least 4.
Yeah.
Well, 3 plus Mr. Campianu.
Yeah.
But the context is, this is not a case where you can say, well, okay, they didn't call those 4, but they did call all these other people, a lot of whom dealt with similar issues or gave evidence about similar things. And therefore, in the context of that, it's not unreasonable that they didn't call these 4. So that was the point I was looking to
Yes,
make, was they didn't actually call anyone really who could deal with any of the key red flag substantive issues. Mr. Bates definitely couldn't, Mr. Porter definitely couldn't, and Mr. Neary was the FCA witness and he certainly couldn't. And the tribunal were absolutely right when they said that all the witnesses that were called were really peripheral to the allegations. So that was the point I was trying to make about the other witnesses. I hope that leaves that issue. So, the tribunal's decision, as set out in the main judgment and the Coss decision, was, as I say, firstly, the only witnesses they did call were peripheral and unhelpful, which is true. That's in the main judgment. This isn't the first time that the tribunal has criticised the FCA for not calling witnesses who can give relevant evidence. That's also true. The main judgment set out at length what the failures to call important witnesses were. Also dealt with the fact that there was no explanation during the trial from the authority as to why those witnesses hadn't been called, even though it was a key part of the subject's case. And all of them made submissions about this. And Mr. Neary himself, as we explored this morning, conceded in his evidence that it is relevant in terms of what a person should have done or recognised in terms of red flags as to whether others in the same position with the same knowledge, what they did. And that, we submit, must be right as a matter of common sense. And the authority took the view in the main judgment, the tribunal took the view in the main judgment that it appeared to be a tactical decision by the authority to only call these peripheral witnesses and not to call the ones that would have actually been able to give meaningful evidence.
Could you just show us that?
Yes. It's the authorities bundle, tab 18, page 569. Paragraph 924, which is in the middle.
Oh, yes. Yes, we've seen that paragraph.
Yeah. And then the Coss decision, which we've got in the bundle, core bundle, at tab 5, page 81 to 82. Paragraphs 21 to 24 refers back to
Sorry, 21 to 24.
21 to 24, page 81 to 82 in the core bundle.
Yeah.
Yeah, and what that does basically is to refer back to the relevant paragraphs in the main judgment which deal with the failure to call witnesses who were likely to have given material evidence about key issues. And the tribunal's conclusion in the Coss decision at 118 is that there, and that is page 99, sorry, of the core bundle.
Yeah.
Is there is no question that the tribunal would have been assisted by the evidence from those four witnesses. And that's plain from the findings that were made in the main judgment. And in my skeleton at paragraphs 34 to 36, I explain why. And I've actually set out where those witnesses are referred to in the evidence and the corresponding main judgment page numbers for each one. Including Mr. Narandez. Now, unless you want me to, I won't take you through I'll deal with VRL Campiano separately, but as far as Miss Thompson-Billman and Mr. Courier are concerned, it's there in the skeleton. Mr. Narandez is the one who the authority's position is, well, it doesn't matter because he was peripheral anyway. And that couldn't be further from the truth, frankly, because Mr. Narandez was a member of JBI compliance. Now, remember, JBI is the London branch where Miss Whitestone worked and Mr. Campiani. And he worked for JBI compliance in London. And he was the compliance officer who was specifically tasked with being the compliance person, the go-to person for the Russia desk, which is the desk that Miss Whitestone and Mr. Campiani worked on. And therefore, when Mrs. Whitestone said, and she pleaded this fairly and squarely throughout the RDC proceedings and in the tribunal, that she had consulted local JBI compliance and had sought and obtained agreement to particular things, what she really meant was Mr. Narandez. And in particular, she said that Mr. Narandez was the person who advised her on the structuring of the commission for the first FX and how it could be done and how it should be done. And secondly, he also advised her on the creation of and the drafting of the veto letter. Now, I know that the authority now say, well, that was never part of our case anyway. The position is you wouldn't have known it during the tribunal proceedings because it was taken up by them, it having been introduced by Mr. Wrightson and pursued with vigour. And it was a matter that had to be dealt with extensively in submissions. And of course was a matter, even if it wasn't an allegation of lack of integrity on its own, had the tribunal accepted what was being said as true, it would inevitably have impacted on her credibility and general integrity, and would therefore have made a difference to the allegations of integrity being made. And her case was, he advised me on how to draft this. Now, maybe he got it wrong, but I wasn't to know that. So that's just two examples, but there are others that I've put in the skeleton, why he was a really important witness and why the tribunal decided he was. And that feeds into a point that is made quite strongly in the case law that says that appeal courts should be slow to interfere with judges' value judgments and exercise of discretion because they don't necessarily enumerate in a judgment every single word and nuance that they have experienced during the course of the case. But that doesn't mean that they don't have a feel, an important feel, for why a witness is important. And therefore, when it's said, shortly stated, that Mr. Narandez would have been an important witness, why that was. But it's clear from an analysis of the judgment why that was. So where the authority says that Mr. Narandez was peripheral, that's just wrong. So those are three important witnesses. And then we have Mr. Campiani. Now, there is no doubt that he was central to the many aspects of Mrs. Whitestone's case. And had he given evidence, I accept that there would have been things that he would have been likely to say that Mrs. Whitestone would not have agreed with and would not have considered to be truthful. However, there were also a number of other matters that he may well have been likely to say that were relevant, such as the way in which she was treated, whether or not she was bullied, his involvement in and awareness of various issues, like, for example, the issue of whether he did look at all her contact notes on My CRM, which would have included him looking at the contact report where she records the split commission arrangement. He says in an email, yes, I did. I've looked at everything. It all looks fine. We can sign this off. She can be given her bonus.
I don't think, if I may say so, that we are in a position to go behind the tribunal's finding that they would have been greatly assisted
Exactly.
by his evidence.
No, but the authority simply say, well, never mind about all that. We don't think he's a witness of truth, and therefore we shouldn't have to call him. And as far as we're concerned, that's the end of it. That's really what their position is.
Well, yes. I mean, as it's evolved this morning, I think their position is we choose who we wish to call. We call those we choose. We don't call those we don't choose. There's nothing you can do about it.
Yeah. And he's not a witness of truth anyway, is what they say.
Yes, they say that too.
Yeah. Whereas they, of course, they can't say that about the other witnesses. The position about Mr. Campiano is obviously different in terms of the position as regards the other witnesses. Because, apart from anything else, he's not regarded by the authority as a witness of truth. In fact, during the tribunal proceedings, the FCA's approach was a bit more nuanced than that. Their position was, where his evidence was corroborated by someone else or a document, then we do it. So it wasn't all one way. They weren't saying that everything he said was a lie. And it's often the case that witnesses will not be all one way for one side or the other. Now, in this case, the authority says, well, given that we decided he wasn't a witness of truth, we don't or shouldn't have to do any more. But what they didn't do, and this is where the tribunal's cost decision lies, I submit, is they didn't give any proper consideration as to whether, despite their own view, although their view was, as I have said, more nuanced than they have suggested, whether there was a way in which his attendance could be managed in a way that was fair to all parties and assisting the tribunal. Now, the fact that the tribunal hasn't, in the past, summoned anyone under Rule 16 and ordered them to answer questions doesn't mean that it's something that the FCA is not required to consider, because it's in the rules. They can read them, and it is well known that the tribunal has flexibility in its approach in any event. And what it could have done, and the tribunal's view in the cost decision was that it should have at least gone and sought directions, raised the issue, and then all parties could have attended. There could have been a hearing. The tribunal could have made decisions, and Rule 16 could have been considered, and any other potential course of action could also have been considered. So, for example, the authority says, well, we couldn't call him and turn him hostile straight away because the case law says you can't do that. And I've made clear in my skeleton, I accept that that's right. There has to be something more before you can turn a witness hostile in the sense envisaged in the case law and certainly in the criminal court.
Is that true in the tribunal,
Well,
where the rules of evidence don't necessarily apply?
So sometimes it's just a question. After one question,
yes.
the court will be asked to treat someone for permission for them to be treated
Yes,
as hostile.
the difficulty is with treating someone hostile that
Well,
they
it's not,
would normally need to give evidence that is adverse to the party calling them, which is contradictory to what they've said before. So usually what happens is there's a witness statement. The person says, I saw person A shooting person B. Then they come to court and they say, nah, never saw person A, he wasn't there, didn't see anything, nobody got shot, nothing to do with me. Now that would be a classic situation where a witness has gone hostile, in the legal sense of the word, because he is given evidence adverse to the person calling him, which is contradicted by the witness statement that he has made and is the reason why he's being called.
Well, I think the test is they have to evidence an intention not to tell the truth or be truthful.
Quite.
If it has to be party calling.
Quite. So if the person then goes on to explain, well, you know, now I've thought about it, I've had my cataract operation, and I now realise that now I can see clearly, I couldn't possibly have clearly seen what I thought I saw. That might be different.
Yeah.
But aside from a reasonable explanation, prima facie, there would be a ground there to apply to turn somebody hostile. What you can't do, I accept, is call someone knowing that they're hostile, and the minute they are hostile, say, right, we now want to challenge your credibility. That's what the case law is saying.
But you can call somebody and tender them to cross-examination.
Exactly. There are other things you can do, one of which is you call them and you tender them. And then people get to ask the questions that they want to ask, including the tribunal. That's one way you can do it, and is commonly done, particularly in the criminal courts. The other way that you can do it is for, as I've said, the tribunal to call them, and then any party can ask the questions that it wants to ask, including the tribunal.
Yeah, I mean, there might have been an interesting question whether Rule 16 has extraterritorial effect, but that would have been discussed on the application for directions.
Yes, I don't know where Mr. Campiano is, and I don't know where he was at the relevant time. But if that was an issue, then no doubt that could have been something that would have been discussed.
I thought he was in Switzerland, was he not?
Sorry?
I thought he was in Switzerland, was he not?
I don't believe so, but I may be wrong. To be honest, I don't know where he is, I'm afraid, and I didn't know then, and I don't know now. And I've no realistic means of finding out. But yes, if that was an issue, then that's something that could have been discussed on directions too. And the other matter is that the case law that's cited in the bundle seems, in my submission, to be suggesting that if a witness is called by a party and then gives evidence that is unhelpful or against the party calling them, then the party can contradict that evidence by calling other evidence. But what they can't do is just purely attack credibility. So that's another potential mechanism that could have been explored with the tribunal, had the authority done what it should have done, I submit, and raised the matter.
Yeah.
I don't know if you want the citations for the other cases, but it's if I can give it to you, but it's they're in the bundle, the cases that relate to the issue of turning hostile. Each one of them makes the same point that you can do that.
Yeah.
So there are other things that should have been done with Mr. Campiano. With the other three, as I've said, in the end, why does all this matter? Why do these absent witnesses matter? Why did they matter in the context of this case? Firstly, because, as I've said, the authorities' case hinged on showing whether somebody had a lack of integrity, and it is relevant for the reasons I've explained to at least consider what other equally well-placed people did or didn't think at the time. And the authority suggests that that was never part of its case, and it wasn't focusing on what other people did or didn't know, and therefore it's not important to call those witnesses. And that was certainly developed when Malone Friend was dealing with ground 3, which obviously doesn't concern Miss Whitestone directly. But what ground 3 and the documents that you looked at in relation to ground 3, if I can simply make an overarching point, show, I submit, is that the authority clearly didn't really address its mind to the issue. That if other well-placed people who were people of integrity, who ought, according to to know better, didn't see red flags, and they had the same information, then they just didn't consider that that was an important part of their case, and they should have done. And that's why ground 3 is relevant, because it is the run-up, if you like, to then what happened during the tribunal proceedings. But I can't develop ground 3 anymore. The other reason why all of this mattered was because you've got to put in context that this wasn't just a case where the authority didn't call a few witnesses, but they made other gross, inexcusable and serious failures, which went to the heart of the fact-finding exercise and the evidence that the tribunal was being asked to use to make its decisions. These are all dealt with at paragraph 28 of my skeleton, which are, yeah, and I've summarised what they were, 28, and then the subparagraphs thereafter. So, excessive and unjustifiable delay. Investigation proceeding at a glacial pace, but actually that delay fed into a lot of the problems that then occurred. So disclosure failures. Tribunal found that it couldn't be satisfied that there were no other relevant documents that should have been disclosed. The failures were so serious that the tribunal made a direction under section 133A5. Failure to gather relevant documents caused the tribunal to find that it's highly likely that potentially there are documents which haven't been made available to the tribunal which are relevant to the issues in dispute. And that's due entirely to the authority's failure to search for and gather relevant material from plainly relevant sources, including, I should say, Mr. Naranda's email inbox, which was never asked for and never obtained. So the overall approach to the investigation started with the internal report by JBI, what's referred to as the Eversheds report. Now, it is clear that in the end, the tribunal did not adopt every word of what's in that report, but certainly from my client's perspective, the purpose of that report was to make her a scapegoat for what happened in order to exculpate the bank. And that was the mindset upon which the authority then approached Mrs. Whitestone herself. And then not conducting an independent investigation, a thorough investigation, but instead just taking the JBI investigation and going with that. And when Mr. Neary gave evidence, I cross-examined him about all of this, and it was agreed that, in effect, what happened was staff were deployed onto other things, long periods of time where nobody was doing anything on this case.
But sorry to interrupt you, Ms. Scott. Does this feed into the cost decision the judge actually made?
Yes.
It was part of his overall consideration of the case. He rejected the main ground that both your client and Mr. Seiler advanced for making an overall costs order.
Yes.
And then he came to the question, should he make a partial cost order?
Yes.
And my reading on that is that that is on a far more limited basis than the generic failings that you've identified.
I agree.
That he referred to at the beginning of the cost judgment, cross-referring to the main judgment.
I agree. And I'm not suggesting that the cost judgment findings of unreasonableness were based on all of these investigative failings. What I'm saying is that all of these failings made it all the more important that witnesses were called, because the tribunal could not safely rely upon the documents it had been provided with being complete and accurate, and on the FCA having done a thorough
So you're saying these failings underline the importance of the witnesses themselves?
Yes, exactly. Because just give me a moment, because I think there is a reference to this. Yes. So in the main judgment, paragraph 151, which is at page 426, so 1846.
I'm so sorry, I didn't catch that reference.
18, tab 18, page 426 in the authorities bundle.
Thank you very much.
And it's paragraph 151. The FCA, as summarised there, effectively said, well, there may have been problems, but the evidence that you've got, tribunal, is coherent, proportionate and fit for purpose. That's what was said at line 2 to 3 of 151. But 152, the authority said, but in circumstances where, and this is 4 lines down, where it's likely that there are gaps in the evidence, we must take that into account. And then at 153, they make the point about important to assess how other people reacted at the time when considering whether a person's reaction shows a lack of integrity. But this wasn't a case where the authority could ever, the tribunal could ever safely rely on the documentary picture.
Yeah.
If it had been, then that may have been a relevant factor for the tribunal judge to consider on the issue of costs and unreasonableness, because calling of witnesses would have been less important. But calling of witnesses when you have an incomplete evidential picture entirely due to the fault of the authority, and then saying, but it doesn't matter because we don't have a duty to provide you with the evidence from these witnesses so that these questions that can be asked of them. And then saying, well, Mrs. Whitestone did or didn't tell Carolyn Thompson-Beelman about this issue. And then she's not called so that she can't be asked about that. All of those things are factors that the judge is entitled to consider within the ambit of his value judgment as being relevant to why, in this particular case, not calling these witnesses was unreasonable.
Yeah.
That's my point.
Right.
I hope I've made that clear. Maybe I should have expressed it more clearly. But the other point I would make is the issue of, well, they didn't take proper steps, because that's a key part of the cost decision. It's not that they weren't called on its own.
Quite.
They didn't take proper steps.
What they did
In
was feeble
reality,
and
they did
late.
Virtually nothing. And I say this for the following reasons. They never sought to interview the Swiss witnesses themselves, ever, or to ask FINMA to interview them. As it happens, limited interviews were done by FINMA, including with Miss Thompson-Beelman and Mr. Courier, but done on FINMA's own instigation, because it decided it had better do a bit of an internal investigation, which it did, and then nothing came of it. But nothing that they did was asked for by the authority. And well, we don't have transcripts. What we have are notes. They're 4 pages each, and they are peripheral. They're not in the bundle, I'm afraid, but they're peripheral, and they do not deal with most of the key issues. So the authority did absolutely nothing during their 6-year investigation to try and obtain evidence themselves from any of these people. They gave no explanation to the tribunal during the hearing about why these witnesses weren't being called. And all that they now say to that is, well, we're not required to waive privilege. And that's absolutely true. But what they are required to do is to take the consequences of their own lack of candour. which is that they give no explanation during the hearing, and then they provide a limited audit trail for the purposes of the cost proceedings, which leads to, in the opinion of the trial judge and the cost judge, a pattern of, in effect, lack of candour. The reality, as the judge was entitled to find, was that the authority knew it hadn't taken adequate steps, and the minimal evidence that it had wouldn't have withstood scrutiny in the main hearing, as indeed it didn't during the cost hearing.
Yeah. I mean, by the summer of 2021, when these decision notices were issued, I think it's fair to say we were all pretty familiar with Zoom and
Quite.
Teams and so forth.
Quite.
So I'm not quite sure why the FCA thought the witnesses had to come to London, either for the purposes of the preliminary interview or indeed to give evidence to the tribunal.
I agree. I agree, and that's all part of the global life that we now live.
Although there may be restrictions, I think, in Switzerland under the Swiss financial regulations. I think there might be, but I'm not sure.
Yes, it's complicated.
Yeah.
It's not a blanket ban, as I understand it, but I think there are some form of at least procedural, if not judicial, hoops that have to be gone through before it can be done. But the point is, if you've got 6 years, you've got time to do that. They had 6 years and they didn't do it. The only moves that they made to contact these witnesses was 3.5 months before the tribunal, which was never going to be long enough to try to institute any kind of formal mutual assistance provisions, whether under the Tribunal Courts and Enforcement Act and the High Court rules, or the CPR or otherwise. And the timing is instructive, I submit, for the reasons that I've set out in my skeleton, which is that what comes across, despite my learned friend's valiant attempts to suggest otherwise, is that they just didn't really want these witnesses. Their point is, well, the comment that we made to FINMA in our letter, paragraph 16, that we expect most of them are going to refuse to cooperate, was never meant to be passed on, and it wasn't passed on in terms. Doesn't matter, I submit, because if the authority had really wanted these people, it could have communicated with FINMA earlier, and B, in a rather more proactive, front foot forward way. What it was really saying to FINMA is, we don't think that they're going to help, and we're not really asking you to do anything other than to just put us in touch with them. And that is manifestly insufficient. And it's also important to note, and for this I'm afraid we need to go to that letter in the supplementary bundle, which is tab 11 in the supplementary bundle 3002. But in addition to paragraph 16, at paragraph 11, which is at the bottom of 3003, the FCA says the following. The FCA now wishes to approach potential witnesses to ascertain if they will be prepared on a voluntary basis to give evidence to the Upper Tribunal. Some of the important potential witnesses who have knowledge of these matters and have been interviewed about them previously, albeit not by the FCA, are based in Switzerland. So that was the FCA's view as expressed to FINMA, that some of these witnesses that they were intending to ask FINMA to contact for them were important potential witnesses who have knowledge of these matters. Now, unless that is untrue or incorrect, that is a very telling statement as regards what the authority really thought about these people.
Well, on the basis in line 1 of 17, they say it's necessary to establish contact with the relevant witnesses in June 2022.
Yes.
Sending a letter on the 16th of June 2022 could not necessarily be described as thinking ahead.
No, and I've set out at length in my skeleton summarising for each witness, including the ones that I accept are not part of the cost decision, but are there for full context, that when the tribunal described the efforts that the authority actually made feeble was an entirely apt description. And were never likely, frankly, to come to fruition. And it is plain, I'm afraid, that appears to have been the FCA's intention. And that's why when they comment at paragraph 16 of that same letter, it's important for the FCA to demonstrate to the Upper Tribunal that we tried to obtain all relevant evidence, should not bear the entirely innocent explanation that Mr. George ascribes to it, but actually a statement of the real intention of the authority, which is we need to do this for show, but not because we're actually expecting that anything's going to come of it, even though these are important witnesses. So the tribunal judge, who's presided over a nearly 3-week trial and done a 199-page judgment, is very well placed to make a value judgment about the reasonableness or unreasonableness of that behaviour in the context of this case. And that's what he did. My last point, I don't think I need to spend any time on this, yes, is the high hurdle that in any event there would have to be cleared before the Court of Appeal would interfere with an evaluative decision, let alone a discretion of a trial judge, which is well summarised in the case of Ascarazioni, Walker Lilly, and also, of course, various eateries. And I can give you the references if you want them, but I would.
Those are cases, of course, in which it is possible to appeal on fact.
Yes, and those were points addressed.
This case, it's not possible to appeal on fact. You can only appeal on law.
Quite. That's true. And in any event, this case is not an appeal against a fact necessarily, it's against a value judgment. My submission is that...
Yeah, and I think I'm making a point that may be in your favour.
No, I understand that. I know you are.
The test is stronger.
No, I know you are. My point is that it's stronger because it's not appealing a fact. So it's easier to appeal a straightforward fact than a value judgment or a discretion. That's my first point. My second point is you're absolutely right, that this isn't a jurisdiction in which the authority could have brought such an appeal as was brought in those cases. And therefore the hurdle for them is even stronger because they have to show that the decision was in effect wrong in law because it was unprincipled or because it was irrational. And there's, in my submission, just simply no basis for either finding. I don't know if I need to develop that. That was my point 3, but I don't know if I need to develop that in any greater detail. It seems to me it's just enumerating very well understood principles. The last point is the issue of whether the authority had properly understood and evaluated what the decision was actually based on in the first place, so the cost decision. Because, and I think I've probably already covered this, but what the authority appeared to think was that this was all to do with the failure to call witnesses. And it wasn't. It was to do with failing to properly consider the witnesses and failing to make reasonable efforts to obtain evidence from witnesses or sufficiently consider how it might call witnesses or what steps can be taken. So it is much wider than simply the failure to call. Yeah. And the same point applies to Mr. Campiani and the failure to even consider the seeking of directions. And all of this stems from the fact that the authority approached the case throughout from its own point of view. And that was clear in the submissions from Mr. George in relation to ground 3. The authority said, well, it's about your thought processes and your integrity, not about what these other people thought and whether they lacked integrity. So therefore, all we have to do is focus on you, ignoring the fact that in order to prove what was in the minds of the subjects, they were relying on the extensive documentary evidence, but wholly incomplete, where emails were being sent by other people containing information that they'd clearly been given, inferences that can be drawn about what those other people were or were not told, without calling those other people and not having a clear evidential picture. So that's why ground 3 becomes more important, because it's part of a similar pattern of the authority just not understanding that it's not enough to just say, this is our case, we're going to focus it in that narrow way, and there's nothing you can do about it. And the other false premise of the authority is this suggestion that rose a lot in the skeleton, but perhaps less in oral argument today, about whether the authority, the tribunal's cost decision was contingent on a false premise that it had to exhaust all avenues in order to call a witness. The cost decision didn't decide it on that basis. What it said was, no, you have to make reasonable effort. And reasonable effort will always be fact-specific, I submit. Because what's reasonable in the context of one case and one particular witness is going to always depend on what is the case, how important is that witness in the context of the case, how close is that witness to the key issues that the tribunal has to determine. So it's always going to be fact-specific and therefore within the realms of a judge's value judgment. And then the last point that they raise is they say, well, this is an issue of considerable importance to the conduct of future litigation. And I'm not sure that that's being pursued, because it doesn't seem to me that that on its own would meet the test that the authority would have to meet for the purposes.
Well, it's one of the aspects of the this is no different from civil proceedings point, I think.
Quite. And I think I've already dealt with that. But the point is that if it does cause them to reconsider and do better in the future, then that is a good thing. And it is consistent with the overriding objective as set out in Rule 2. And so therefore it doesn't assist them at all in terms of the decisions that you have to take. So in conclusion then, as I have said, what the authority have been forced to do is to try to shoehorn their case on this appeal into a legal error of principle or an irrational decision that wasn't reasonably open to the tribunal. But in actual fact, on proper analysis on the context, the factual context and the legal context, neither applies. Because the reality is that this decision was properly made on the basis of a trial judge's unique perspective of all relevant matters. And insofar as there were references to analogies to be drawn with judicial review proceedings, what the tribunal clearly meant to say, by reference to 88 and 89 of Frensham, which it cites in the cost decision, is that it's actually a far more nuanced point than that. But it is a valid point, and therefore it is not wrong in law to have taken the view that they did. Can I assist further?
No, subject to the question whether you want to put anything in writing about the difference between these kinds of proceedings and ordinary civil litigation.
Is that something that perhaps a friend and I need to discuss before we give a collective answer to the tribunal? Because obviously if the authority consider that they're going to put in further submissions, then I will do so as well.
Yes.
Would you mind if we just confer?
Yeah.
Yes, all right, fine. Yeah, so Mr. George is suggesting that he replies and then we can discuss the matter after that, which I'm happy with if the court is.
Yes. It's 19. Yes, Mr. George. Do you wish to reply?
I will threaten 8 points, but many of them are brief. The main one I seek to deal with is this question of shoehorning, and is there a point of law here? And I reiterate, in my submission, we're entitled to start page 107 of the core bundle, and the fact that the supervisory nature of the tribunal's jurisdiction and the key differences between proceedings of this kind and normal civil litigation are the stated basis, the one relevant consideration for reaching this decision. So we are entitled, we say, to look at that and ask, is there an error of law disclosed? And we have the tribunal's reasoning at page 418 of the bundle of authorities by reference to the main decision. And I'm not going to repeat what I have said about the analysis in Frenchman, but my lord and my lady have heard what has been said and conceded or accepted in relation to the analogy with judicial review, and what has been said and to some extent conceded in relation to the analogy with duty of candour. And with respect, if I may endorse my lord's point with relation to the true construction of section 133(6) at page 11 of the authorities bundle, if I may, my lord. So that's going back to 1336. And respectfully, we submit, my lords and my lady are absolutely right when they say that what the tribunal must do, they either dismiss the reference 6a or 6b, they remit the matter to the decision maker with the direction to reconsider and reach a decision in accordance with the findings of the tribunal. But those tribunals can only be a issues of fact and law, and that factual and legal determination is the only historic matter which they will be able to make findings about. But then in B and C, future matters, they can make findings about what should happen in the future, both matters to be taken into account and procedural or other steps to be taken. So when one looks at what the analytical reasoning for these key differences between civil proceedings and regulatory proceedings were, in my submission, not only was the analogy with JR and the duty of candour inapt, but the construction of this particular provision was incorrect. The reality is the only historic jurisdiction the tribunal has to look at historic matters relates to fact and law. And in my submission, if I'm right about that, I have shown an error of law in the analysis and the reasoning on which the tribunal approached matters. That does not mean that you can't reach the same result for other reasons, or that you can't say, well, actually, taking everything around, we reach the same decision. But it does mean that I am through that hurdle, because I'm not shoehorning this in. I'm taking the tribunal's own guidance and signpost as to where to find the legal analysis on which they relied. And so one then asks, well, what are the key distinctions between civil proceedings and regulatory proceedings if the JR analogy and the 133A construction, which is what the tribunal relied upon, are incorrect? And in my submission, there is nothing to support a submission that when it comes to this witness evidence or the nature of the factual ambit that the authority is required to investigate or put before the tribunal, there is any distinction between these proceedings. My lord has our point about 133A6. The supervisory jurisdiction, I understand the tribunal sits in judgment on the FCA, but in terms of what it does, it is a full de novo fact-finding jurisdiction in that regard. And I'd said in the outset to a question right at the beginning that I could see supervisory jurisdiction could be used in some contexts, but not in the way, in my submission, this tribunal has sought to draw on it.
The sense in which it's supervising the FCA is in relation to the remedy
Precisely.
which it can grant.
And also, my lady and my learned friend referred to it, one can see over the page at 133A5, page 15. I will have seen this. The tribunal may, on determining a reference to the decision of the FCA, make a recommendation as to its regulating provisions or its procedures. So there is that extra provision, but that doesn't have anything to do, in my respectful submission, with the evidential fact-finding matter. It is not supervisory in that sense. It's a full jurisdiction.
Yes, in other words, contrast judicial review, the Upper Tribunal is not saying, was it open to the FCA to come to this conclusion? The Upper Tribunal is asking itself, was this the right conclusion on the facts?
Precisely. And once it has found the facts, then, as you can see, it might remit it. But obviously, if the facts are that these people acted with full integrity, and they acted with full competence, to take a hypothetical example, there's no room for the FCA to manoeuvre. So in that sense, it's, I don't want to say it's a token, but it's a mark of respect, perhaps, to the FCA. It doesn't actually have any substantive decision. And so where, at least as far as third-party witnesses are concerned, does one find any material distinction between these proceedings and general civil adversarial proceedings, or indeed other disciplinary proceedings related to other professions to which matters have been averted? And in my submission, one doesn't. Well, I'll discuss with my learned friend whether we can usefully assist more in writing. I will hand up now with the Court's Appeal just the references to the general tribunal rules I cited earlier, just so that you have them. These are the case management powers and the requirements to provide statements of case, simply so that you have them, because I made the submission, which I repeat, perhaps inelegantly, but these rules look like the civil procedure rules, if I can put it that way, in that they are defined by pleadings and they have these case management powers. And if this was to be a different type of jurisdiction, one might expect to see it there. And to turn the opposite point around, I was asked very fairly, well, what sort of rules might you expect if it was an inquisitorial jurisdiction? And I merely note, for example, that the coronial rules, the coroner's jurisdiction being inquisitorial, have very different provisions at Rule 21. Unless the coroner otherwise determines, a witness must be examined in the following order: first by the coroner, then by any interested person, and then the witness's representative. So you do have jurisdictions that plainly highlight different evidential formula, but these rules don't. And in my submission, there is no key distinction material to this appeal between civil proceedings and tribunal proceedings. And as I say, my lord, if I'm right about that, then the tribunal has misdirected itself in that analysis. Now, the point made against me quite fairly is that a key point of what the tribunal is getting at also relates to, well, you didn't take sufficient steps. You didn't ask for a directions hearing. You didn't issue a letter of request. You didn't think about Mr. Narandes. But in my respectful submission, all of those are predicated on the basis that we had a duty, because these proceedings were different to normal civil proceedings, to consider those things in that light. And I accept that is right, in that if these are an inquisitorial jurisdiction, and if we have a duty to bring before the tribunal all material and relevant evidence in the width with which they have said, then of course one should take those type of steps. But if the tribunal was wrong about that, and we do not have that duty, and this really is civil litigation, subject obviously to the rules and civil procedures about witnesses who you could be expected to call, about not misleading, about, but if that is right, then there was no need to call for a directions hearing in respect of Mr. Campiani. There was no need to issue a letter of request in respect of Ms. Thompson-Beelman and Mr. Courier, and there was no need to take any further steps in relation to Mr. Narandes. So in my respectful submission, if I am right about this starting point, and this analysis about the key differences between proceedings of this kind and normal civil litigation, then neither the fact the witnesses were not called or the steps that might have been taken preparatory to that can stand, because they are all based, in my respectful submission, on that misapprehension as to the key differences between proceedings of this kind and normal civil litigation. And none of those submissions give any encouragement or carte blanche to an authority to mislead or to act inappropriately or to act improperly. They simply relate to the nature of the factual evidence it should be calling before, in order to prove its case and to contest a case before the tribunal. The other 4 points I make are brief and relate to specific points, my lord. Firstly, it was said there's sort of total inequality of power, if I'm right. And in my submission, that's plainly wrong. The ability to compel a witness is open to the tribunal on the application of either party. And the ability to ask or to begin proceedings for a letter of request are similarly open to either party. Just in respect, for example, of Mr. Seiler, who had the benefit of D&O insurance, so I accept Mrs. Whitestone says she did not, costs of £1.6 million were incurred by one of the leading solicitors firms in the area. The idea that they could not have taken those steps, could not have from there sought to find out Mr. Campiano's whereabouts, wherever he may be, is not, in my submission, credible. They had ample resources to do that had they so wished. We did not have any greater resources when considering it on a material way. Clearly, either party could have applied for a summons, either party could have applied for a letter of request. My lord, you have been addressed, it's there in the skeleton. I understand the points my learned friend has made about factors such as delay and disclosure and matters, but they are not part of the reasoning of this costs decision. They are not why we have been found to be unreasonable. And they cannot provide relevant context if I am right in my submission that this decision is premised on and underlined by, as the tribunal said, the perceived supervisory nature of the tribunal's jurisdiction and the key differences between proceedings of this kind and normal litigation. My lord, in relation to the Swiss evidence, you'll have seen from the supplementary bundle at paragraph 30.07 that was part of the text and the communication with FINSMA that the FCA is not permitted to take witness statements in Switzerland. As my lord identified, the matters are complicated. All I can say is this. When Mr. Seiler and Mr. Wrightson appeared in a video hearing before the RDC, it was their explanation to the FCA, and we accepted it, I mean, we didn't sort of seek to challenge it, that they could not participate and make oral submissions on their behalf in that RDC hearing, even though it was by Zoom, because that was giving evidence from Switzerland. That hearing took place during the time of either lockdown or travel restrictions. They weren't able to leave Switzerland, and that's the reason, it's not in the bundle, but that's the reason they did not speak to the decision makers of the RDC at the time. So, my lord, I don't have Swiss law evidence to give you, but basically there is evidence that you can't get round by Zoom this prohibition on taking evidence in Switzerland. Zoom is as bad as travelling in person, so that's why that view is taken.
There's case law in the Upper Tribunal, immigration and asylum chamber on similar points.
My lady, yes, and I mean it's also right to say, and I'm sure my lord in particular is aware. I mean the sanctions for getting this wrong are draconian. I mean Swiss law takes it extremely seriously if you breach this rule. And the final point I make, my lord, is simply in relation to the points of principle. My lord, you're obviously right in the various eateries at point that you make, that if you could appeal on fact, that gives you an extra limb. But in my respectful submission, and we all quoted the relevant passage in various places, so I won't turn it up again, but I am submitting for this court to decide that the reasoning of the judge discloses, the reasoning of a tribunal discloses an erroneous point of principle, which is what I'm not attacking a fact, I'm attacking that point of principle. And my alternative ground is not a factual attack, it's a irrational fact where I have raised it, and my lord has seen that. That is only the question of further material, and we obviously are very willing to assist in any way. Our position would be, what has been said against us by the judge is that there are key differences between these proceedings and civil proceedings, and that's why this all has to be done. We have looked and made submissions about the two relevant legal sources relied upon for that conclusion in tribunal jurisprudence, which is one, the judicial review duty of candour analogy, and to this specific section of the FISMA. We are not aware, and we'd tell you if we were, of any other provision that would be relevant within FISMA or the rules to that, beyond those which I have submitted to you, or my learned friend has submitted. I've just shown you section 13385. We've both referred to the tribunal's power to call a witness of its own motion, and I have shown you the structural powers, which in my submission are analogous to those set out in the civil procedure rules. I'm not sure you will necessarily be assisted by my coronial rules, but I have drawn attention to how it is done very differently elsewhere. But from the authorities part, as I say, we are quite happy to be directed and to assist in any way that we can. But like my learned friend, I'm not aware of this tribunal having said anything more on the subject than we have both addressed. And in a sense, my submission is really that the decision is predicated on certain key differences. Yeah. And I say, having addressed as best I can, and my learned friend is obviously equally assisted, what material there is that is relied on to say there are key differences that there aren't. And I've shown you by reference to the structure of the procedural rules why they are actually similar. And as I say, my submissions are limited really to third-party witnesses and that type of factual evidence. There are different considerations for when the authority puts forward its own explanations for its own evidence. So, my lords, I don't want any of that, my lady, to suggest we're not prepared to diligently research and submit. But at the moment, I think we would say, we understand there isn't a huge volume of material, but this concept of the key differences between proceedings of this kind in normal civil litigation, as far as we are aware, does rest on the material which we have drawn to your attention. Unless, sorry, I should ask, neither Ms. Rooney nor Ms. Mayor, so unless I can assist you further.
All right, well, thank you both very much for your interesting arguments. We will reserve our decision. We will get drafts in the usual way. That is your opportunity to correct our English but not our reasoning and not to introduce new points. The draft comes with an embargo, which means what it says, so be careful who sees it. If you need more information about the width of the embargo, it's all in the General Counsel for Wales case, reference to which will be on the draft itself. We would hope that in the light of the draft you will be able to agree an order disposing of the appeal. But if you can't, then please make written submissions and we will make the order that we think is appropriate. Thank you all very much.
Court rise available. Checking while you were talking, I think that's right, because I think I spent quite a long time. And then you could possibly say, well, we could look at what's happening in the criminal court.
Doctors, dentists, we go through the lot, but yeah.
The point is, that's not what